This court has been called upon to clarify the constitutionality of several aspects of the law concerning military trials. Even if the arguments gravitate around trials in the general court martial, the points raised radiate to the whole military court system. I note that the 4 grounds of appeal and the one in the cross appeal raise cross-cutting issues. And this explains why some submissions by counsel on a particular ground were as well reiterated in other grounds. All the grounds contain an element of counter to the challenge raised against the competence of the general court martial and know its status as a court of law. Whereas the standing of the general court martial as a court of law was not raised as a separate ground of this appeal, and yet it was a separate question for determination in the Constitutional Court, upon which the court rendered a decision declaring them to be tribunals. It was implicit in all the terms of appeal that it was an issue. In determining this appeal, therefore, I adopt an integrated approach where a ground may be disposed of in the course of considering another ground. For instance, the status of the general court martial as a court has a bearing on the resolution of grounds 3 and 4, which entail the determination of the issues of personal and subject matter jurisdiction of the court respectively. During the period after hearing this appeal, the laws of Uganda were revised. The UPDF Act is now cited as the UPDF Act, Chapter 330, while the impugned sections 2, 119, 1H and G, and 179 have changed to sections 1, 117 G and H, and 177 respectively. However, there is no change in the content. In this appeal, I consider that the issue of the establishment of a court of law, its subject matter or personal jurisdiction, its structure and the fairness of its procedures, and the exercise of judicial power are distinct questions. In that regard, the specific issues for this court to resolve arising out of the Constitutional Court decision, the grounds of appeal and cross appeal are: 1. Whether the courts martial are courts of law duly established under the Constitution or are tribunals. 2. Whether the courts martial can be or are independent and impartial within the meaning of Article 28(1) of the Constitution. 3. Whether civilians can legally, that is without offending the Constitution, be liable to face trial in the courts martial for disciplinary offences, hereinafter called military, disciplinary or service offences, stipulated in Part 6 of the UPDF Act. 4. Whether civilians can constitutionally or legally be tried in the courts martial for civil offences not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislations. 5. Whether it is constitutional for persons subject to military law to be tried in the courts martial for offences outside the UPDF Act, hereinafter called civil offences. 6. Whether it is constitutional for civilians to be tried by the courts martial as principals for offences under Section 119(1)H of the UPDF Act, yet these also exist as civilian offences. This court is aware of the rules of constitutional interpretation and has set them out in detail. You'll find I've set them out in the main judgment, is a detailed coverage. Counsel for both parties have, in support of their cases, cited several Ugandan authorities. These include Second Lieutenant of One Ambrose, against Attorney General, Sergeant Paul Kalemera against Attorney General, and others. Other relevant authorities that have also been delivered since the hearing of this appeal, and upon which counsel in this petition have had no opportunity to submit on, are retired Captain Amon Biarugaba and 169 others. The second, Honorable Ambrose of Uganda, this is another decision for the lieutenant. If that falls on this court, we ensure certainty in the application of the law by clearly spelling out the principles that should guide on how to structure and how handle matters concerning discipline in the UPDF. This will ensure that the provisions of Article 209 of the Constitution are given effect to, without affecting other provisions of the Constitution. It will also ensure that the enforcement of the provisions of Chapter 4 of this Constitution. Ground 1 is the General Court Martial lawfully established as a court of law. Under Part 8, titled Military Courts, the UPDF Act provides for the Summary Trial Authority, STA, Unit Disciplinary Committees, UDC, and Courts Martial. From the outset, it is clear that the STA and UDC are not established as courts, but as tribunals. The Courts Martial, established at the Division Court Martial, established under Section 196, which is now 192, the General Courts Martial under Section 197, which is now 195, and the Court Martial Appeal Court, established under Section 199, which is now 197, and the Field Court Martial under Section 200, now 198. It is clear that the long title provides that the Act is passed under Article 210 and not 129 1B. However, I do not consider that failure to indicate Article 129 instead of 210, as was done in the long title of the UPDF Act alone, is enough to take away Parliament's power given to create a court under Article 129 1B. The General Court Martial is part of the courts of judicature referred to under Chapter 8, albeit with a special limited jurisdiction. The other argument for consideration is whether the creation of the court under Article 129 1B requires an amendment of the Constitution and not a referendum. Under Article 259 of the Constitution, an amendment of the Constitution can only be done by an Act of Parliament whose sole purpose is the amendment of the Constitution and pursuant to the requisite parliamentary procedure for such amendment. I have duly given consideration to the provisions cited, Article 129 that establishes the Court of Judicature, Article 128 that provides for the independence of the judiciary, and Articles 259 and 260 do not stipulate that the creation of a subordinate court per se requires an amendment of the Constitution. Article 129 merely lists the courts of record and provides that the creation of other subordinate courts shall be as established by laws made by Parliament. The UPDF Act is one of those laws, and Section 197(1), now 195(1) thereof, establishes the GCM. It is also evident that the Constitution contemplates the existence of courts martial. See, for instance, Article 2572A and Article 203B of the Constitution. It was contemplated that owing to the unique nature of military work matters or military discipline should be handled by special courts, court martials in bracket, and military tribunals, UDCs and STAs. The issue whether the General Court Martial is a court was conclusively settled in Attorney General against Mushabe and Attorney General against Uganda Law Society. It would, however, do well if Parliament clearly stipulates in the law enacted the status of a court created as the Magistrates Court Act does. I note that in Attorney General against Mushabe, This court came to the conclusion that since the GCM exercised judicial power, it is or must be deemed to be a court. On the contrary, my finding is that the legality of the establishment of the General Court Martial, not based on its exercise of judicial power, but on the authority conferred on Parliament under Article 129, 1D of the Constitution. Exercise of judicial power and tribunals. Before I take leave of this issue, I would like to address myself to the aspect of the exercise of judicial power by courts and military tribunals, upon which the learned justices of appeal based their decision in retired Captain Amonde Arugaba. As a general rule, in a democratic society or dispensation, every aspect of judicial power must be exercised by a competent authority established by law. Judicial power, which is exercised by the judicial arm of government as an institution, as is provided for in the Constitution, refers to the authority vested in the courts of judicature, whose judicial officers interpret and apply the law, resolve disputes, and administer justice generally. In a narrower sense, judicial power generally uniquely involves an exercise of power to interfere with the personal liberty of persons who appear before it. And this usually falls exclusively within the realm of ordinary courts of law, although there is no express bar to criminal exercise of jurisdiction by some tribunals. Tribunals usually exercise quasi-judicial power as opposed to judicial power of the courts. As a characteristic, the moment an entity can hear criminal cases and give custodial sentences or detain its suspect during hearing, the entity exercises judicial power regardless of its title as a court or tribunal. In other words, the exercise of judicial power is not in all cases what differentiates a court from a tribunal. I have noted that under the UPDF Act, the UDCs and STAs, UDC is Unit Disciplinary Committee in case you have forgotten, and STA is the Summary Trials Authority, that are established as tribunals, have been given jurisdiction to try offenses and sentences that they can impose range from caution to custodial sentence. Pursuant to Articles 23, 126.1 and 129.1 of the Constitution, it is only the courts that are granted the mandate to interfere with personal liberty in the sense of custodial sentences, or any legal detention of a suspect for an extended period of time during a hearing. Therefore, in the Ugandan framework of military courts, it is only the courts martial that are established as courts of law under the Constitution that can properly or legally be said to exercise judicial power when hearing offenses, criminal or disciplinary, with the power to impose custodial sentences and detain suspects. The UDCs and SPAs are tribunals. Hence, whatever judicial powers they exercise are unconstitutional, as they do so without lawful authority. Ground number 2. Every court established under the Constitution must meet the criteria for a fair hearing. Similarly, tribunals entrusted with judicial power have to apply the principle that ensure a fair hearing, and for this, the classification as courts or tribunals bears no relevance. The right to fair hearing is one of the fundamental human rights that are considered an imperative in any trial. See Article 28.1 of the Constitution of Uganda as amended. The UDHR, Article 10 of the UDHR, Article 14, Paragraph 1 of the ICCPR, Article 7 of the African Charter. The guarantees of the right to a fair trial applies to all courts and tribunals, including military and other specialized courts. The principle of equality. Judicial power, even though it is limited in jurisdiction, has been devolved to military courts to be exercised in line with the Constitution, while respecting the fundamental rights and freedoms of individuals appearing before them. It goes without saying, therefore, that all persons, including military personnel or persons subject to military law, are entitled to the non-derogable right to a fair hearing. Although a soldier becomes subject to the military system, he does not cease to be a citizen, and his rights as a citizen remain relevant, albeit in an amended form. But whatever legislation is applicable, it must still be interpreted in light of the supreme law. Can a military court be independent, fair, and impartial? A military court can be independent, fair, and impartial. Thus, trial of a person by court-martial does not per se occasion a violation of the person's right to fair hearing provided for under Article 28(1) of the Constitution. That provision does not specify the composition of procedure adopted by such a court or tribunal, other than listing the procedural safeguards required for a fair hearing. However, as noted earlier, Article 128 of the Constitution also imposes a requirement as to objective independence of the court or tribunals exercising judicial power as a safeguard to fair hearing. Proof. An individual who challenges the independence of a tribunal need not prove an actual lack of independence. See the case of General Oaks. In a particular case, the challenge can touch on the whole structure and procedure of the courts. Similarly, this is an objection to the system of trial within the General Court Martial in its current structure. Test for independence and impartiality. One may be considered to pass the test for independence and impartiality and thus ensure a fair hearing in military courts has been a subject of wide consideration and discourse. With regard to independence, Article 128(1) of the Constitution provides that, quote, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority, close quote. Article 128